Let me go grab it.
How do you do that, sir? So can we get flowers for the next meeting? I love it. Oh, right here. Okay. Yeah. Perfect. Yeah.
She's checking right now. He's home having video.
Not civically minded.
He's not free. He's video game minded.
How's your day off? Not your day off. How's your day at home?
It's good, but just, I missed you guys, and I know it was a busy day.
We all missed you. You were lost.
Yeah. I missed you too, Charlie. For the record.
Can you see that it's recording fine?
Yes, it's live. It's recording. Do you want me to zoom it in at all? No. Okay.
Alright everyone, we're going to get started. Thank you all for being here in this very weird, weather-wise, Chicago evening. Thank you all for making the trek to this beautiful place. We're so lucky to be here. We're so lucky to have all of you. I know it was not ideal weather-wise to be here, both because of the rain and because of the air quality alerts, so we really appreciate you all being here. We're going to get started in the interest of time because we have a lot of people that will be presenting and that will be here with us today. And so, my name is Commissioner Osvaldo Gomez, and the June 29th, 2023 meeting for the Community Commission for Public Safety and Accountability is called to order. We will begin by calling the roll call to establish quorum. Commissioner Beth Brown? We'll circle back to her. Commissioner Cliff Nellis? Commissioner Osvaldo Gomez is present. Commissioner Renate? Commissioner Driver is not with us. He is the president, and so in his absence as the vice president, I will be chairing. Commissioner Isaac Troncoso. Present. And Commissioner Edel Boisa. Present. With 6 members of the Community Commission for Public Safety and Accountability present, we have a quorum, and we can conduct the Commission's business. The next item of business is public comment. If you would like to share something related to the Commission's work on public safety and accountability, there are a few options. You can speak at the public meeting. You can also submit public comment by writing an email of your comment to Community Commission Public Comment at cityofchicago.org. Those are the words Community Commission Public Comment at cityofchicago.org. You can also bring a copy of your comment to one of our Commission's public meetings and give it to any one of the commissioners that are here or someone from our Commission staff. People who wanted to speak during the public comment period tonight were asked to submit their names in writing earlier, and the names were drawn at random by a member of the Commission staff. Speakers will be called in order in which their names were drawn. If your name is called to offer public comment, we ask that you approach the microphone that's lined up here. Please state your name repeat your name once you begin your comment. Spell your name as well, and then begin your comment. Each speaker will have 2 minutes. You will see a clock over there that will indicate when your time is up. today in our public comment is Mayra Gomez Santana, who is also a very appreciated member of our non-citizen advisory council. Thank you, Mayra.
My name is Mayra Gomez Santana, it's spelled M-A-Y-R-A, G-O-M-E-Z-S-A-N-T-N-A. I'm bringing some information about what was brought to my attention. Governor Pritzker announced 2 weeks ago that he is ending health insurance eligibility for undocumented migrants ages between 42 to 65 on July 1st, which is 2 days from now. In addition, he is opening enrollment for undocumented immigrants ages for ages 65 and older. The Non-Citizens Advisory Council wants to encourage you who are listening and let people know about this. Between 42 and 65, tomorrow is the last day to sign up. We are devastated by this decision and hope that the governor will reconsider this. Thank you for your time.
Thank you, Mayor, for your comment. The next speaker is Jeff Tischhauser. I'm sorry if I'm mispronouncing your name.
You got it right now.
And remember to spell your name.
Yeah. Hi, my name is Jeff Tischhauser. That's T as in Tom, I-S-C-H-A-U-S-E-R. And I'm a senior research analyst with the Southern Poverty Law Center. I'm working on a report on policing around the country. And Chicago, CPD is one of my case studies. And I recently submitted a FOIA to find a list of prohibited groups. So under General Order 8, right, Section 3, so-called criminal organizations, right? The Gang Intel Unit, as well as the Intelligence Unit, is expected to maintain a list of banned groups. The new proposal, and this general order has been on the books since 1997. The new, there's a proposal going around, your office has looked at it. The list is going to be taken over by the Bureau of Counterterrorism. I submitted FOIAs for the past couple of months to these units looking for the list, and the CPD response has been alarming. They said that they cannot find the list. They did not deny my request. They said that they cannot find it. So I'm just here to raise this issue. Hopefully we can get some kind of clarity on the existence of this list. I'm not expecting answers tonight, just trying to raise awareness, and thank you for your time.
Thank you for your comment, Jeff. Our next and final speaker is Elizabeth Rochford, who is a district council member as well. Thank you for your time and service.
Thank you. Elizabeth, spelled the traditional way, Rochford, R-O-C-H-F-O-R-D. As well was said, I'm a district council member from the 17th district. A couple months ago, we had some information as district councilors about an educational conference in November on community policing that we were encouraged to go to. The cost of the conference is $675. That would be 1 month plus a quarter of the stipend that we get. So that it seems to me that for a lot of people that's probably pricey. So I'm asking the commission to find out if the city has any educational dollars that they could potentially contribute to maybe one, if not all, of the district councilors from each district go to the conference, or help us find maybe some grant funding from private institutions, because I think this would be a great educational thing for the district councilors to be a part of, but I just think it's cost prohibitive, so please consider that, and then let us know when our quarterly meeting is with you all, because we're looking forward to meeting with you. Thank you.
Thank you, Councilor Rochford. That concludes the public comment period. Thank you again for those speakers that offered your comments. We value your input, and we will talk more about opportunities to continue to stay engaged. And just a note for the audience, normally the commission doesn't answer any questions that are offered in public comment. We will follow that same process today, especially in the absence of our president. The next order of business is the approval of minutes. Before today's meeting, draft minutes of the commission meeting held on April 27th were shared with all commissioners. Are there any corrections to the draft minutes that have been circulated? If there are no corrections, is there a motion to approve the minutes of the commission meeting held on April 27th?
So,
Second.
Commissioner Terry has moved to approve the minutes of the Commission's April 27th meeting, and Commissioner Brown has seconded. The mic wasn't on. Is there any debate on the motion? Any debate on the motion? Cool. Hearing none, we'll move to a vote. Those in favor of adopting the motion, please signify by saying aye. Okay, any opposed? The ayes have it, and the motion carries with the majority of the commissioners voting aye. Our next order of business will be new business. I will begin by discussing District Council vacancy recommendations for District Council 1. Back in February of this year, for the first time ever, Chicagoans all over the city elected 3 members of district councils in each police district. However, only 2 people ran for the district council positions in the 1st police district, which covers the Central Police District. As a result, on that day, the district council members were inaugurated on May 2nd, creating a vacancy for District Council 1. Under the Chicago Municipal Code, Section 280070, when there is a vacancy in the District Council, the existing members of the District Council have 30 days to nominate 3 candidates for the vacancy to the Commission. The Commission then has a total of 60 days from the creation of the vacancy to select one of these candidates to be recommended to the mayor for the appointment of the district council seat. The mayor will then have the opportunity to choose someone to fill that vacancy. Pursuant to this part of the law, the 2 elected members of the District Council 1, Sarah Kammerer and Jamie Brown, held an application process that through the course of 30 days. After the application period closed, they reviewed the application and nominated 3 candidates to fill the vacancy. The Commission has reviewed the application materials and has conducted interviews. At this time, we are prepared to vote on our selection to recommend to the mayor. Is there a motion to select a person to be recommended to the mayor to fill the vacancy of District Council 1?
I move that the commission select Marcel Bright to recommend to the mayor for appointment to fill the District Council 001 vacancy.
Seconded. Great. Commissioner Terry has moved to select Marcel Bright to recommend to the mayor to fill the District Council 1 vacancy, and Commissioner Troncoso has seconded. Is there any debate on the motion? Great. Hearing none, we will move to a vote. All those in favor of adopting the motion to select Marcel Bright to recommend to the mayor for appointment for the filling of District Council position vacancy, please signify with an aye. Those opposed, signify with an aye. Those opposed say nay. The ayes have it, and the motion carries. Congratulations to Mr. Bright. I don't think he's here, but either way, we can talk about it. Okay, great. Now, moving on to our next order of business is the affirmation of district council member positions. The Community Commission Ordinance and the ordinance that created the Community Commission and the District Councils says that each District Council must have a chair, a community engagement coordinator, and a nominating committee member. District Council members have 30 days after they were sworn in to officially determine who will fill these positions. If the District Councils did not choose within 30 days, the ordinance says that the Commission had the power to pick who will serve in each position. Every district council has now held its first meeting and voted on position assignments, but several of those meetings took place after 30 days. Since a few of these votes on positions happen after the timeline, the Commission is voting today to ensure the validity of those positions. And just to be clear, the Commission isn't deciding who will fill those positions. Each district council made that choice for themselves, and the Commission is just voting to make those choices official. It's a technicality under the ordinance, but we want to make sure that we follow the law. On the Commission's webpage, there's information about the District Council position assignments, and I believe that there is a QR code where you can see each of those positions for your district councils. Given the responsibilities laid out for the commission in the ordinance, I move that the commission officially recognize and affirm those district council position assignments that were voted on more than 30 days after the district council members were sworn in. Do I have a second?
Second.
Great. So I moved as Commissioner Gomez to officially recognize and affirm those district council position assignments that were voted on after 30 days. 30 days after the district council members were sworn in, and Commissioner Brown is second. Is there any debate on the motion? Great. Seeing no further debate, those in favor of adopting the motion to recognize and affirm district council position assignments, please signify with an aye. All those opposed, please say nay. The ayes have it and the motion carries. Now, our next order of business is reports and updates. We will begin with an update concerning the CPD superintendent search process. Commissioner Terry, you can begin.
Thank you, Commissioner Gomez. As mentioned in our previous meetings, the Commission is responsible for conducting a nationwide search for the next superintendent of the Chicago Police Department. The Commission's process began with input from the community and will conclude with the Commission sending 3 candidates to the mayor. Then the mayor either choose one of 3 candidates that the Commission recommended or request a new list of 3 names. Ultimately, it will be the mayor who selects the new superintendent from a group of 3 that the Commission sends over to him. The Commission began by developing an application that laid out key qualities that the Commission was looking for in a superintendent. We posted the application on the Commission's website and worked to spread the word about the opportunity. We then worked to gather more information about what to look for in a superintendent. We received input from hundreds of people across the city and across the country. The goal was to ensure we were qualifying candidates through a holistic lens that was deeply informed by input from community members and subject matter experts. Our outreach efforts included 7 community forums to gather community input on the qualities that they would like to see in their superintendent. A survey that was posted on our website generated over 250 responses. A survey that was sent to police personnel, which generated 270 responses. Over 24 subject matter expert interviews, including law enforcement personnel from Chicago and other places, academics, public safety practitioners, and outreach workers. Meetings with 3 of the police unions, the Fraternal Order of Police, the Sergeants Union, and the Lieutenants Union. We also conducted 8 listening sessions with various community sectors, including labor, legal aid, social service agencies, affinity, business groups, faith, activists, and advocacy groups. We collected applications for 4 weeks, and we ultimately ended up with 54 applications. Every commissioner reviewed applications and assessed them based on the qualifications that were laid out in the application brochure and the issues that were highlighted through all of the outreach that the Commission has conducted. The full Commission selected a group of applicants to interview. Commissioner Driver and I interviewed all the candidates who the Commission selected. Then the full Commission conducted a second round of interviews with those top candidates. Under Illinois law, the Commission can interview candidates and discuss them in closed meetings but must make a final decision about the top 3 candidates in an open meeting. Sometime within the next 2 weeks, the full Commission will meet in a closed session to discuss and vote on the top 3 nominees to send over to Mayor Johnson for consideration. That will require a special meeting of the Commission. The date, time, location of that special meeting will be announced at least a week before the meeting. And the information about the meeting will be posted on the Commission's website and emailed to anyone on the Commission's email list. The nominations must be delivered to Mayor Johnson by July 14th, and the mayor must select a superintendent by August 13th or decline to pick any of the candidates the Commission commission provided, and then explain in writing the reasons for not picking any of the candidates. If the mayor rejects all of the candidates recommended by the commission needs to come up with a new list of 3 candidates. That process continues until the mayor picks a superintendent from the commission's list. The mayor's selection is subject to city council approval.
Thank you so much for that update, Commissioner Terry. Are there any questions or any comments or updates from the commission? I see Commissioner Troncoso.
Thank you, Vice President Gomez. I would like to make one comment that I think is really important, reflecting back on the superintendent search, which is that for all the evidence that the commission has been able to find as far back as data has been available, this appears to be the most applications we have ever had for the position of superintendent in the city of Chicago, at least in the past 20 years in which we've been able to find data from the police board's website. So I think that's something really important to keep in mind, that this was a very competitive process, and I believe that says something.
I see Commissioner Bethbrown.
Just to clarify, if we're holding a special meeting, we're not required to give a week's notice, are we? Aren't we required to give 48 hours for a special meeting?
For the special closed meeting of this nature, we still have to give the week's notice.
Really quickly, Adam, do you want to chime in further on that?
At the last meeting, the commission authorized, under the Open Meetings Act, a series of closed sessions for the narrow purpose of reviewing applications and conducting interviews. And under the Open Meetings Act, the commission could hold those closed sessions with just 2 days' notice. For the special meeting that will be required for the public vote on the finalists, that under the commission's ordinance requires 7 days' notice.
Any other questions, comments from the commissioners? Great. Okay, I know there's a lot of questions that probably the public has on these. Will be available in room room after if you have specific questions. But since we have an agenda and I'm seeing no further questions on the matter, we'll move on to the next issue. And that is the discussion of the Chicago Police Department goals. And Commissioner Brown is going to be giving us an update on it.
Commissioner Nellis and I met with Interim Superintendent Fred Waller and other senior leadership for our second quarterly progress meeting for goal setting and performance evaluation last week. Since we established the superintendent's goals, former Superintendent David Brown resigned, Interim Superintendent Eric Carter has resigned, and Interim Superintendent Fred Waller began his role as head of the Chicago Police Department in the middle of May. Despite these transitions, we're committed to continuing to hold CPD accountable for the goals that we established for the superintendent. Our expectation is that the senior leadership who surround the superintendent in title and duties will continue to support the goals during these transitions. At this meeting, we will hear from police board representatives and the COPA chief executive about progress on their annual goals. CPD is not presenting today because the commission did not ask Interim Superintendent Waller to provide any goal updates at this meeting, but we do look forward to hearing from the new superintendent presenting in future commission meetings.
Commissioner Brown and I hold CCPSA goal check-in meetings with the superintendent as key staff quarterly to continue our assessment of his performance throughout the year rather than just being at the end of the year. By doing it this way, we can discuss and amend the goals as needed due to timing and other factors that may need the goals to be adjusted. Our intention is that this process be collaborative as we work to strengthen the department and improve public safety. Given this is our first time as a commission conducting this type of goal evaluation, we continue to discuss with CPD the best way to evaluate the performance and assess each goal. We have not yet landed on an evaluation metric that we all feel good about yet, but that's in the process.
In the second quarter, we received several deliverables from CPD, including an update on the department's workforce allocation study, the CAPS and Neighborhood Policing Initiative and PI Integration Planning, and the Department's Holistic Officer Wellness Strategy. In our second quarterly meeting with CPD, we also discussed status updates for several goals related to CPD's management and infrastructure, partnerships with community, and human resources goals. We also received updates on several quarter one goals, including their strategic planning training goal. CPD reported that up to 10 members of CPD's senior staff, those that are affiliated with the superintendent's office, have almost completed the University of Chicago Booth Executive Education Program titled the Advanced Strategy Program. Commissioners expect that training like this will give these trained CPD personnel the tools necessary to draft comprehensive strategic plans, support the execution of these plans, and evaluate progress forward.
One of the key management and infrastructure goals that was set for the superintendent is the execution of a workforce allocation study. And in our second quarter meeting, we discussed the status of the workforce allocation study with the superintendent. Superintendent Waller has opted for the permanent superintendent to take the lead in deciding the scope and who will conduct the workforce allocation study. CPD and the commissioners discussed some of the potential barriers to completing a comprehensive workforce allocation study. And we encourage CPD to take proactive steps in preparing for a workforce allocation study to overcome any of the expected challenges in assessing workforce allocation. We also told them they know some of the issues already regarding workforce allocation. We expect them to begin implementing necessary changes now.
The commissioners discussed several of the partnership with community goals, including the expectation that the superintendent collaborate with the commission on drafting general orders, having a superintendent or a representative attend every commission meeting, and district council engagement. There has been some moving around of commanders and supervisors due to promotions and other factors since interim superintendent Waller began on May 15th. The commission would like to remind CPD that district council folks have been working to establish relationships with district commanders and others. When a commander is suddenly moved to another district, the district counselors should be informed, as they will be losing someone with whom they have a relationship and will need to begin over with a new person. The commissioners talked to the superintendent about encouraging district leadership to go beyond just attending district council meetings and to also look for ways to become active participants with the district councils between the meeting times.
We also asked CPD about their expansion of the Neighborhood Policing Initiative. This was one of the goals set for this year. We found out that during COVID and after, NPI's efforts of disjointed leadership and participation and was in need of some revival and renewal. So CPD is currently focusing on strengthening the existing NPI programs, something that my law school actually agreed with. Before moving into expansion of other districts, commissioners also look forward to a quarterly update on the officer wellness planning and an update on the training plan in our third quarter meeting. I will add that we did ask for a plan which would outline how we look into expand the NPI program for all 22 police districts. The plan doesn't necessarily mean that it's done. It's supposed to plan to do it. So during the goal setting meeting, CPD and commissioners also discussed CPD's response to migrants and asylum seekers in police stations. Commissioner Brown asked that the police department, in addition to any verbal guidance that they provide to district leadership staff, that they also provide written guidance to all police district leadership about the way in which they are expected to receive and treat immigrants living and congregating at their station. Every crisis has both danger and opportunity. The opportunity for CPD in this moment is to shine and to treat our new neighbors like they would want their own families to be treated. We hope that all districts will treat every new neighbor with dignity and respect, as so many districts have done so far.
Thank you, Commissioner Brown and Commissioner Nelson, for your update. Are there any questions from other commissioners on this issue? Okay, thank you for that. I think this is a very important part of the work that we do. But seeing no further question on the matter, we will now move on to the next section of the agenda, which is the Commission selection policies for the COPA chief appointments and the police board nomination. Commissioner Loizan is going to give us an update on that. Commissioner Loizan, go ahead.
Thank you. At last month's public meeting, the Commission presented drafts of 2 policies for public comment. Procedures for appointing the Chief Administrator of COPA and procedures for nominating people to serve on the Police Board. The Commission is responsible for each of these actions as part of our oversight authority over COPA and the Police Board. Before I continue to explain these policies, I want to remind everyone about the important functions of these 2 police accountability bodies. COPA and the Police Board are both involved in addressing police misconduct. COPA investigates complaints of police misconduct, incidents where an officer uses a firearm, and incidents where a person dies or is injured in police custody, among other things. The Police Board is a 9-member public body that reviews cases of misconduct brought by the police superintendent and cases of misconduct where COPA and the police superintendent disagree about how an officer should be disciplined. The Police Board also reviews appeals from people who are found ineligible to serve as sworn officers of the CPD, and they set the rules and regulations for the police department. We created these policies to give our work more structure and more transparency. We also created them to show compliance with the Chicago Consent Decree, which calls for major overhauls to how policing works in Chicago. Most of the consent decree's obligations apply to the police department, but the paragraphs of the decree related to the selection of the COPA chief and police board members go to the Commission. The Commission plans to finalize these documents in the coming weeks with the goal of officially adopting them at our next regular public meeting on July 27th. If you would like to review these policies, you can view or download them from our website homepage. We welcome public comments on these draft policies. You can email your comments to Community Commission Public Comment at cityofchicago.org. Before I wrap up, I just want to make it clear to everyone that our implementation of these policies does not mean that any of the people currently holding these positions are going to be replaced. We simply have created a policy that is open for public comment so that in the event that happens, we are prepared to make sure that we can get that done promptly.
Thank you, Commissioner Loizan. Are there any questions for Commissioner Loizan from other members of the Commission? Seeing none, we'll move on to the next matter. Our next order of business is police board nominations, and Commissioner Isaac Troncoso is going to give us a little bit more information on that.
Thank you, Vice President Gomez. So as mentioned, the Commission is responsible for nominating candidates for the police board. As we described earlier, the police board is a 9-person public body that reviews and decides in cases of police misconduct brought by the police superintendent against a police officer. It also decides on cases where COPA and the superintendent disagree. It decides on appeals by applicants to be police officers who were disqualified based on a background check. It adopts rules and regulations for governing CPD, and finally it holds monthly public meetings just like the Commission. When a police board vacancy occurs or is approaching, our job is to bring 3 candidates to the mayor's office to fill the vacancy. Or we can recommend reappointment of a current member whose term is expiring or has expired. The application process for the police board is ongoing. Individuals who are interested in serving on the police board can apply at any time, including today, by submitting a cover letter, resume, a list of 5 references, a completed eligibility form, and a completed conflict of interest form. When a vacancy occurs or is approaching, we will consider all applications we've received at that time. But as I mentioned, right now we are actively seeking applications. In August, we have multiple seats for consideration. For one of these seats, the current member will not be seeking reappointment because he has reached his term limit. That means we will have at least 1 seat to fill with new candidates. We will also consider new applications for other seats in addition to reviewing applications for reappointment. We have received many applications that are currently under review. If you are interested in applying, we recommend you apply as soon as possible. Please submit your application materials to policeboardnominations@cityofchicago.org. The application materials are on our website. You can also access the application using the QR code behind me. But again, thank you to our staff. But again, those required materials are cover letter, resume, list of 5 references, a completed eligibility form, and a completed conflict of interest form. Both forms are on that website. To qualify for the police board, you must meet the following criteria. You have to have been a resident of Chicago for the last 5 years. You have to not be a current employee or former employee within the past 5 years of the Chicago Department of Law, the Chicago Mayor's Office, CPD, COPA, or the Cook County State's Attorney's Office. You also have to have at least 10 years of combined documented experience, including postgraduate education in law, law enforcement oversight or police accountability, public policy, social work, psychology, mental health, community engagement, or organizing or civil rights. You cannot have a conviction in a U.S. court for bribery, embezzlement, extortion, perjury, or any other corruption-related offense. For any conviction, you must be able to show successful rehabilitation. So again, if you would like to apply, go to the Commission's website, send applications and questions to police board nominations at cityofchicago.org, and I'll make one other shout out. If you are a district council member, we will gladly attend your meeting to speak about this in your community. I'll do so even if I have to sign up for public comment to do it. And if there are any questions, I'll turn it over to Vice President Gomez.
Thanks. Any questions or comments on that matter? And thank you to Commissioner Troncoso for volunteering to do that. Okay. I want to just echo that this is an important opportunity. This is a huge position that has incredible impact on many people, both in the department and outside. As we continue to build a stronger city with more equity in our public safety system and more trust in our institutions, it's important that everyone here be participant in making that recruitment happen. We all know someone who has 10 years of experience in psychology, mental health, community engagement, public safety, organizing, and civil rights. And I know that because I know many of you. So let's get out there and do that. One more thing from Commissioner Troncoso, and then we'll move on to the next issue.
I'll just say that I should have extended that invitation to bring one of us to your meetings to any organization, whether it's a garden block club or a neighborhood association or anything. You don't have to be district council member in one of those meetings. Any community meeting at all, we will gladly attend and speak about this.
Great. We're going to move on to a similar issue, but a little bit different. We're going to talk about police board and COPA goal updates. So Commissioner Troncoso is going to give us a brief little overview, and then we're going to hear from one of our guest speakers.
So in addition to nominating individuals for appointment to the police board, the Commission has the duty and authority to establish annual goals and expectations for the police board president. These goals are not developed in a vacuum. We communicate with the police board president during the drafting process, receiving his suggestion and input before officially adopting a set of goals in January. At the end of the year, the Commission must complete a performance review of the police board president based on that year's goals. We have the same responsibilities as we do towards the Chief Administrator of COPA and the Superintendent of CPD. This year is the first full year of the Commission's existence and the first time we've established goals and expectations for these 3 offices. In January, we adopted a set of goals for Police Board President Guion Foreman after much collaboration. And for today's meeting, we have asked for an update on the Police Board's progress in meeting their 2023 goals. President Foreman was unable to attend. In his place, we are very grateful to have Vice President Paula Wolf and Executive Director Max Caproni, who are here to provide an update and answer questions from commissioners. Vice President Wolf and Executive Director Caproni, thank you for joining us at our public meeting this evening. Can you please share your update at this time?
Thank you for. Sorry. Thank you very much for having us. Don't have me on it for the 2 of us to make up for his absence. Thank you. So Max is the one who does all the work. I just push the envelope. So we're going to let him handle most of these answers, and then I'll chime in.
Thank you very much, Vice President Wolf. I'm Max Caproni, Executive Director of the Police Board, and Deanne Foreman sends his regrets. He's traveling on business out of the country and couldn't be here, so he asked the two of us to come and give you an update, and I'm happy to do that, and then we're happy to respond to any questions that you have. So the Police Board President has 11 goals, as Commissioner Troncoso mentioned. We work collaboratively with the Commission to establish these goals. So what Vice President Wolf and I will do, we'll run down, give you a summary of where we are with these goals, and then again, happy to respond to questions. The first two goals relate to the consent decree on policing in Chicago that was mentioned earlier in the meeting. The goals are that the board achieve full compliance with the paragraphs in the consent decree that apply to the board and for which the board is responsible, and in particular, achieve full compliance on the 3 paragraphs regarding training for board members and hearing officers that are in the consent decree. So I'm happy to report that earlier today, as you may be aware, the Independent Monitor released the 7th semi-annual report on compliance with the consent decree. The board is responsible for 14 paragraphs in that consent decree. For 11 of the 14, we have full compliance. And for 3, we have preliminary compliance. And it's the 3 paragraphs on training for which we have preliminary compliance that we're working on and have the goal of meeting full compliance by the end of the year. So we are working, the board is working with a law firm, Jones Day, who is serving pro bono to help develop the training. One training session is currently developed and under review by the Monitor and the Office of Attorney General. And then we have additional sessions to be completed, to be developed and then completed by the end of the year. So we're making progress on that. And I'll turn it over to Vice President Wolf, who wants to speak about one training initiative in particular.
So this is one where I think we could use your help. What we're trying to do is develop a training that gives the board members a perspective of what it's like from the community to have the police come into the community. For a long time, the police board did ride-alongs with the police and got a sense of what it was like from the police's perspective to come into a community. We'd like to do the opposite. We think that Jones Day, our pro bono law firm, will work with community organizations or others to try to figure out the best way to do this and also comply with the consent decree, but we really need the intellectual input, the substantive input from the community to be able to figure out how to do that. So anybody who has any ideas, we would really appreciate it from the commission, the council, and anybody can get in touch with Max. Thank you.
Moving on to Goal 3. Goal 3 relates to one of the requirements in the consent decree that requires the police board, COPA, and the Public Safety Inspector General to meet quarterly and discuss various matters. And the goal here is to have at these quarterly meetings discussions of issues that may arise in police board cases. And we've discussed at these meetings 3 main issues that impact the board's work on disciplinary cases. One is the process for resolving disagreements or ruling on disagreements between COPA and CPD when they disagree and can't reach agreement on discipline of a police officer. There's a current process in place where one board member reviews and makes a ruling, and we've discussed at these meetings possibly having the city council, putting in a request to the city council to change that process and to improve it. A second item that we've discussed at these meetings are what are known as Rule 14 cases. Rule 14 prohibits officers from making false reports. The Inspector General recently released a report on the enforcement of Rule 14, and we've discussed in these meetings how the police board approaches those cases when we do have those cases filed with the board. And then a third issue that we've discussed at the meetings is a issue related to the time limit for the law department who represents the superintendent before the police board in disciplinary cases, a time limit to file charges. And there is currently an ordinance that Alderman Martin has introduced, and we've discussed the pros and cons of that issue as well. So I think these meetings have been very productive and just giving a forum for discussing these issues. So I believe we're making good progress on that goal. I'll turn it over to Vice President Wolf, who wants to comment on this issue of time limits and timeliness for disciplinary cases.
Thank you. And first, I want to thank your Executive Director, Adam Gross, who's been attending these meetings, and having him here has really been very helpful. 2 points. There is the ordinance drafted that Alderman Martin has put in. We made comments on that. We appreciate it if you have time to look at that. We do think timeliness from the law department is important. What we can't figure out is what is the mechanism to cause anybody in the accountability system to move forward on a complaint. We don't want to have the limit. If you haven't acted within the next period of time, the complaint is dismissed, because then the complaint never gets heard. On the other hand, there are not a lot of levers that we can pull to force the law department, for example, to move these cases along. We're still getting cases that are years and years old. So any ideas you have on that would be very helpful. And I think the other, what is the other issue on that? Oh, to the extent that you can work with the mayor's office and the law department and talk to them about the priority of hiring outside attorneys and moving these cases along, with the new administration, and with your presence, that you can add to what we've been saying for a number of years, which is that there is some urgency, both for the people who have filed the complaint, but also for the officers, many of whom are left either on administrative duty or not being paid while these cases are pending, and they just go on too long. And frequently, we can't get the witnesses that we need and the evidence we need, because people have left town, they've died, and so the cases just don't have the same capacity to be able to be reviewed thoroughly as they would if they were more.
Leaping ahead to goal 5, and the reason we're looking ahead is that also has to do with timeliness. And we've had, as Vice President Wolf mentioned, discussions in these meetings and also discussions outside of the meetings on the importance of moving cases along from the time a complaint comes in until a case is filed with the police board. And then we internally at the police board, the second part of this goal is making sure that once a case is filed, we handle it as fairly and as expeditiously as possible. So I work with our hearing officers who preside over cases to make sure that we are not delaying cases unduly and that we're keeping delays to a minimum. So that's on goal 5. Going back to goal 4, goal 4 relates to the board's role in hearing appeals from individuals who are seeking removal from the Chicago Police Department's Criminal Enterprise Information System, CEIS, which replaces a system that was colloquially known as the gang database. The City Council back in 2021 gave the board a role in hearing appeals. However, we are not moving forward with that appeal process until there's a decision made as to whether to launch CEIS, which is not the board's decision to make. That's a decision that I believe will be made by the Commission and CPD and the Mayor's Office and possibly others as well. So we are pausing on that because there's no sense in moving forward with the appeals process if the system from which appeals would come is not going to be launched. So that's an update on goal 4. Oops. Goal 6 also relates to police board disciplinary cases, and we have been communicating with attorneys who represent the parties in the case the importance of accessing complete information about an officer's work history, both positive and negative. And at 2 points in the process, on the record in police board cases, we make sure that the parties know that they have access to that information, how to get it, and encourage them to take advantage of that so that the board, when it's making decisions, can have as up-to-date information as possible, both on any prior sustained complaints that may be in an officer's history, and also on awards and other types of recognition in an officer's history. So we've been doing that on the record in our police board cases. Goal 7. We have to get into it. Yes, sorry.
This is where I really could go on the reservation. So we get the list of all the meritorious awards that the officer has. As Max mentioned, we only get the sustained complaints against the officers. That's because of the contract with the police union. And one good thing is it used to be limited to 5 years, and now we can go back further. But we don't see unsustained complaints because of the union contract. I'm just speaking for myself now. I think a real accountability system would be able to expose how many complaints have been filed against a person. The police board is in a position always of having to make judgments about whether or not something should be relevant to the decisions we make. And so we wouldn't assume that just because complaints have been filed, that it means that those complaints are necessarily marks against an officer, but I think the volume of the complaints, which, to be honest, frequently we find out about later when we read the newspaper articles about the police officers, would be important. Again, I'm speaking for myself, would be important to understand the officer's history. We know it's a contractual matter, but just wanted to raise it.
Just a quick introduction here. Sorry. I want to make sure that the commissioners have a chance to ask questions as well. So we're running a little bit over time, so if we can make just a little bit more explanation so that I can ask questions. I'm sure commissioners have. But sorry about that.
We weren't filibustering.
No. We appreciate you. This is very thorough, and we're very thankful for it.
Oh, yeah. I think goal 7 is just whether Dion consults with the superintendent before the meetings. He always does, and he also consults with the chief administrator on a regular basis. We also, I think, have been able to have good interchanges with people giving public comment and the police department being there to answer their concerns.
And then moving to wrap up the last 4 goals, goals 8, 9, 10, and 11, all relate to more administrative matters, making sure that board members attend the meetings, ensure that we timely respond to requests for information, including from members of the public, posting on our website information about disciplinary cases, and also on the board's mission. So we post on our website and we track and post data on attendance. For goal 8, we have on our website the FOIA, the Freedom of Information Act portal that we use, the city portal that includes all of the requests that come in, and when we respond to them, we've, I think without fail, responded in a timely way on all of those. We post the decisions in police board cases the evening that they're made at our public meetings. We post the charges against officers once they've been notified. And we have a section of our website on the board's mission, and then links within that website to more detailed information so that they can see, the public can see how we carry out our role. So that concludes our update. So thank you very much.
Thank you for that. Just 1 second before you guys sat down, are there any questions from the commissioners on the updates? I'm going to acknowledge Commissioner Terry and then Commissioner Jones.
Thank you all so much for the update. Quick question. You all mentioned assistance from the commission related to the potential of hiring outside counsel, at least having that conversation with the current mayor. Has this issue been raised, and what has sort of been the pushback, if It has been raised before.
I'm not sure that there's been pushback. I think, and we haven't been involved in those discussions because it is hiring attorneys for one of the parties, the superintendent, to represent them at the police board. So I'm not sure that it would be appropriate for us to be involved in making those decisions, but we have impressed upon the mayor's office in the past the importance of having high-quality representation to prosecute these cases, so that the board is given full information for each case so that it can make the best decisions. So that would be how we've been involved in just talking about the importance of having good attorneys on both sides so that we can reap the benefits of the hearings.
Oh, I was actually referring to the expediency.
Yeah, well, we did have discussions with the prior administration about the rapidity with which they hire and get these cases moving. I think it's fair to say we did not get any response. We didn't get any pushback, but we also didn't get any response. We have not talked to the current administration.
Thank you. Commissioner Troncoso, go ahead.
Thank you. So this relates to goal number 6. First of all, thank you guys so much for being here, presenting super thorough, really helpful, sincerely appreciate it. So since beginning to, you mentioned you've been beginning to ask twice on the record for all information, positive and negative. Since starting that, do you feel as though you've been getting more information? Have you noticed a change at all?
I think, Max and I talked about this, I think we had one case where we've actually had a sustained complaint that we've learned about, but we haven't gotten any information on the unsustained complaints because the contract prohibits that.
And
we always get lots of the record of what the awards are and the positives are.
Thank you. And one question for educating both the public and myself. So you mentioned that previously you were only able to go back 5 years to see sustained complaints, and then now you can go back further. How far are you able to go back now?
So now there's no limit. So with the new union contract, they eliminated that 5-year provision. So now any sustained complaints in an officer's history would be eligible to be considered. Whereas before, if it was older than 5 years, it could not be considered.
Thank you.
Okay, I'll acknowledge one last question from Commissioner Royce, and just in the interest of time.
Hi, it's nice to see both of you. Could you provide us with a little color as to your comment about the city law department and the delays there? I'm not sure I'm clear on what the source of those delays are. Can you give me a little feedback on that so that we understand what the issues are?
So we keep track of how long things take at each particular stage. And once the superintendent makes a decision to move forward with a discharge case, or there's a ruling in a disagreement case between COPA and CPD that requires the case to move forward, we can track how long it takes from that point until the charges are filed by the law department. And there have been a number of cases where it takes a very long time, and our sense is that it's a manpower or person power issue within the law department. I believe there may be some staffing shortages within the law department that would be contributing to those delays. So to the extent that they can either hire more permanent staff or seek outside counsel to work on these cases, we think that those delays would be less.
That's what I was missing, thank you.
Okay, one quick last thing, because I didn't acknowledge it, because most of the tables on this, Commissioner Ellis, you had a comment?
Yeah, I'm ready to blindside. So I actually have some questions. In the interest of time, I'm going to just make comments and we can maybe follow up afterwards. One, I just thought the community training goal was kind of fascinating. I was interested by that, and I was wanting to know what you think is the equivalent of a ride along for community. But we can talk after this meeting. And then the second thing I'll just comment on, I'm going to put on my defense hat, Vice President Wolf, and I think you appreciate this. I can understand wanting to get a history of complaints on officers, unfounded or not. I am assuming there's some complaints that need to get dismissed without a full investigation. There's now either a finding of sustained or not, and then there's some that would be investigated that maybe they were found actually not responsible. And so if you're gonna look at previous unsustained complaints, I think you would do this already, but I would certainly want to have as much information about why the outcome was the outcome, so that it's a balanced decision. Because as a defense lawyer, I would never want arrest records being any kind of indication of guilt of a current offense. And I know you would appreciate that.
So thank you for that. I'm sorry, but in the interest of time, we're going to conclude this section because we have other guest speaker that's been very kindly waiting. Thank you so much to you. This has been super helpful. I hope the community has learned a lot. And I really hope the community will continue to engage. I think we're seeing our organs of government reaching out to communities to try to get you guys involved, to try to get everyone to be a part of this process. Let's make sure that we answer that call. Okay. So we're going to move on to the next order of business, which will be an update from the COPA chief. Commissioner Rosen and Commissioner Brown are going to give us a little bit of context.
Yes, and just to clarify, you said earlier that chief person would be reporting on the goals. She's actually reporting on something else tonight, so Commissioner Loizon and I are reporting on the goals. We have reviewed COPA's second quarter goals and are pleased to share that COPA has met and in some instances exceeded those goals. A report will be published on our website within the next week or so. Now we want to speak. Sorry, can we just confer for a second?
You guys have 2 minutes to confer. Also, your mic is on, by the way. Okay, cool. Go ahead.
I think what we'd like to do is invite Chief Kirsten to speak about something that we've been talking with her about for quite a while, and then Commissioner Loizon and I will come back and be able to then offer our comments as well.
Sounds great. I just want to know that in the interest of fairness, I'll give you the same amount of time for questions and presentation, which was 21 minutes, than our last speaker had. I know that we had given you another 10 minutes, but in the interest of fairness, we'll give you the same time that our previous speaker.
Thank you. I'm Andrea Kirsten, Chief Administrator of the Civilian Office of Police Accountability, COPA. And I appreciate the opportunity to be here before you tonight. While I'm not going to be giving you a full update on COPA's goals, what I am going to talk about actually is one of the key sort of signature goals for us that we set this year, which is about our investigative caseload. When this agency launched back in 2017, it inherited a legacy of sort of lack of distrust in the community about the agency that preceded us. It inherited an understanding that we didn't have the ability to conduct independent investigations, independent from CPD's influence, independent from the mayor's office influence, independent from the court of public opinion. And there's also a lot of issues aimed at our transparency or lack thereof, as well as integrity, investigative integrity. In the last nearly 6 years now of our agency's existence, we have made tremendous strides in all of those areas. I think we have a track record that establishes certainly our independence. We are an agency that is rooted in transparency. That's why I'm here tonight to talk to you about something that may or may not be music to everyone's ears, but it is the reality of the environment that we're in, and I want to be honest about the challenges that we face. One of the remaining things we are yet to accomplish as an agency is about timeliness. The time it takes for our investigations to conclude, the time it takes for those recommendations to make their way to the Chicago Police Department and the officers impacted, as well as the complainants and their families who filed these complaints with us in the first place. So in order to address timeliness, I think we've tried a number of different approaches over the years. And one thing that I think is of tremendous value to the agency right now is that I can stand before you and say our entire senior leadership team has dozens of years together collectively working at COPA specifically. We've all been at this work, trying this from different perspectives, and have come to the conclusion that there are some hard decisions that need to be made about the significant caseload that we have, and I want to be here tonight before you to talk about those choices. If we could go ahead and advance the slide, thank you. So what we are prepared to launch in July, actually July 17th, is COPA's Timeliness Initiative for 2023. We are going to take the remaining time of this year, so July through the end of the year, end of December, to evaluate some of the aging cases in our caseload. We're going to get to the data in a moment, but I can just say kind of globally we have around 1,400 open cases. And I'd like to contextualize that for you, where we've been and where we are now and where we're going. But of those cases, we will be looking at the cases that are 2 years and older. The oldest case in our agency right now is not older than 4 years. That is progress. It may feel like it isn't, but knowing where we started, it is in fact progress. But what we have learned in the last 6 months in particular of this year is talking about when timeliness is not achieved, all of the things that Vice President Wolf and Executive Director Caproni were talking about, the timeliness of investigations and how that impacts police board hearings, arbitration hearings. We learned some hard truths. There are, and especially in the arbitration world, there are really 2 main factors that arbitrators are considering when they are applying the just cause standard and making decisions about whether an officer should be held responsible for allegations of misconduct. And those 2 factors are timeliness and past practice. Past practice meaning what are other examples of discipline that was received for similar or like conduct in the past. There's a lot of things we can't really do about that. We are trying to move forward and make sure that discipline matches the nature of misconduct. But timeliness, or the lack thereof, is a significant hindrance to the successful implementation of disciplinary recommendations. Even those that CPD fully agrees upon and supports with COPA, it's a hindrance to having those stand up or be achieved in an arbitration process. And the timeliness, to drill down even further on it, cases that are over 18 months, eclipsing that 2-year mark, have almost no chance at times in an arbitration process, which is separate and different from the police board, I think that's important to know, of being successful. So when we think about and face the reality of what that time limit looks like, we think about the urgency of the community wanting a reformed police department, officers deserving, fairness in process, deserving to understand when they've made mistakes so they know how to correct it, and complainants and impacted families and parties deserving to know whether or not their experience, how it was resolved and what people thought of it, if their truth was our truth and when we applied the facts to their version of the events. So in order to achieve all of those things in a timely manner, we simply have to reduce our caseload. We've shown time and again that we can close cases quickly. High-profile cases often get prioritized and closed with integrity and independence on a much faster timetable. We need to be able to apply that across the board. Every complaint, whether it's one that's in the media, whether or not it involved a fatality or some other tragedy that's high-profile in nature, every complaint deserves swift resolution. So when we're looking at reviewing the older cases to determine what other posture could we conclude these cases in, we want to say a couple of things up front. First and foremost, there will be a dedicated unit within our investigations division, led by one of our deputy chief administrators who's here this evening, along with the rest of my senior leadership team, as well as my executive assistant, Christina Lee. They're all here tonight because this isn't just my plan. This is a plan that is the product of an agency that is focused on doing its job to the best of its ability. So with that unit, they will be reviewing the caseload of each and every investigator in our office, and they will be applying a criteria as to whether or not a case could be concluded by making a training recommendation, a retraining opportunity for an officer as opposed to some sort of disciplinary outcome. What I think is really important to note is that there will be a number of kinds of cases that just simply won't be eligible for this kind of closure. No officer-involved shooting can be closed this way, no fatality of any kind can be closed this way, no excessive force with serious injury, no egregious acts of civil rights abuse, or egregious act of verbal abuse that's bias-based in nature, no domestic violence, no sexual misconduct, no Rule 14s, the cases where officers are accused of making false statements. None of those types of complaints will be closed under this program. So you may be thinking, what is left? But what is left, in fact, are usually operational violations, often a failure to timely activate a body-worn camera, failure to properly document something in an investigatory stop report, and please make no mistake, those kinds of violations matter. Those kinds of actions are a bedrock of meaningful accountability, right? This is not shirking any sort of level of seriousness for what those allegations represent, but instead saying in situations where there's no evidence that the failure to timely activate a body-worn camera was anything other than accidental, Knowing what we know about the arbitration system, the best path forward would be to seek retraining for this so that we can devote our resources to cases that have not yet eclipsed that age limit. So having said that, I think it's also important to understand that I think other benefits will come out of this as well. Being able to identify other cases requiring prioritization that perhaps we didn't realize needed prioritization, as well as being able to continue identifying operational deficiencies that sort of enabled this caseload to reach the size that it did so that we can make changes proactively going forward. I think the justification is clear. This is about appropriate resource allocation. If there's a lack of likelihood of success for continuing down this path towards an arbitration, what success can we find through training or other non-disciplinary outcomes? But I'd like to dive a little bit further into the data. If you could just, thank you, advance that slide. So this line actually tracks our open caseload over time. And you can see COPA launched in September of 2017 with just under 1,000 cases. I mentioned that we inherited those from IPRA. Back in 2016 and 2017, I worked at IPRA as it was turning into COPA. I know there were conversations between the leaders of that agency, the Department of Law, City Hall, other stakeholders, about whether that inherited caseload should even come to the new agency. You've got examples across the country of other civilian oversight where when one agency was collapsed, they didn't bring those cases with them, and that led to greater success and sustainability for the new iteration. We didn't make that choice in Chicago, and there's lots of reasons why that didn't happen. However, that summer, just prior to the launch, senior leadership of COPA was trying desperately to close some of those older aging cases so that our inherited backlog was less. They were doing so, unfortunately, without a dedicated unit like we will have for this project. They were doing so without the methodology and criteria that we have crafted for this project, and they were doing so without the nearly 6 years of lessons learned about what these cases look like, which cases are more deserving of a serious misconduct allegation, and which cases are more appropriately able to be resolved in other ways. Go ahead, next slide. So as we move through these are kind of some points I'd just like to make as to how that caseload began to creep up the way that it did. Because you can see that first climb there, starting from 2018 all the way up to, let's say, 2020 is about the middle of that. So a couple of things. The week after COPA launched, we lost our first chief administrator, had an interim chief for a period. A new chief administrator was brought on in April of 2018. You can see that box. We had 951 cases at that time. It quickly began to steadily rise, and there are a number of factors for that, some of which are the increased jurisdictional obligation that COPA had. We had never before investigated Fourth Amendment complaints in proper search procedure, so there wasn't a good way to predict what that volume of cases was necessarily going to look like, and also not a great ability internally at the agency to determine what needed misconduct investigations and what needed counseling or training or other lower level kinds of addressing between an officer and his or her supervisor. We also then, as you see the caseload continuing to tick up, launched the consent decree went into effect, which brought 83 separate paragraphs for COPA and its leadership team to work on trying to satisfy, but it diverted a lot of resources and attention. We also launched a new case management system, meaning our entire staff had to be retrained on how to document their day-to-day activities. So there's a lot of things happening sort of in the background as the cases continue to rise. Go ahead to the next slide. We tried again in basically 2019, recognizing, the chief administrator at the time, recognizing that the caseload was hitting a peak, nearing, now I'm too far away to look at what that number says, but I think it was around 1,600 cases or so at that time. And as it was nearing that peak, action was taken at the intake level unit, so those are the cases coming in the door, to try to really get our arms around what was and wasn't working at the time. Some improvements were made, and there was also a back-end process led by the then first deputy administrator to try to close older cases as well. So those two efforts were happening simultaneously, which is why we start to see a decline. However, that progress was interrupted after the civil unrest surrounding George Floyd's murder. That was clearly an episode that led to a lot of complaints being received by COPA at a time where, like every other agency, we were trying to figure out working remotely and all the other challenges with the global pandemic. So that's when the caseload really jumped up to the highest peak, which is almost 2,000 cases. And since that time, we have been steadily working to decrease the caseload. And as you can see, I took over as interim chief in 2021 when we had about 1,600 open cases. Today we have about 1,409 open cases, and because tomorrow is the last day of the month, I will predict with certainty that we will get back down to 1,300 and something by the end of the day tomorrow. Thank you to my team that will make sure that happens. But what's important about where we're at now is you can see that dotted yellow line. We haven't been at this level since April of 2019. So while things have gone as high as they have gone, we have steadily been working to decrease this caseload. However, at this rate, assuming there's not another episode of civil unrest, assuming we don't have significant changes in leadership or other unexpected episodes that occur, we would still need years to get the caseload down to a manageable level where we're able to conclude all of our investigations in 2 years or less. That is why hard choices have to be made. Go ahead with the next slide. So this is just a picture of kind of all of the things I pointed out. Go ahead to the next slide. To show you sort of the percentage of the cases that we're looking at for this program, for this possible review. And it's not to say all of these cases will be closed in this posture, but every case from 2019, which is 13.8%, every case from 2020, and the majority of the cases from 2021 will all be reviewed for this posture of closure. However, if they fall into any of those categories of criteria that I mentioned that are not eligible, they won't be closed that way. Go ahead to the next slide. We also have a very robust communication and public engagement plan tonight in this presentation. The media stuff that we have done around this, stakeholder meetings. I actually gave a similar presentation to the police board in May. Stakeholder meetings with local community groups, city council members, and then also our communications and external affairs team. They're working alongside of the investigative team that's going to be conducting these reviews so that they can proactively contact complainants about this process and make sure that they have their questions answered, they know what's going on with their case, and we don't have them just wait to receive a letter in the mail. So we have a lot of effort that we're putting into making sure that we're being transparent about this. I said at the beginning, you know, not everyone is going to uniformly agree with the methodology and approach that we're taking, but I can stand before you with confidence saying that this plan has been developed in partnership with Commissioner Brown and Commissioner Loisen's feedback, but it's focused plan. This is how we see a path forward for our agency. It's a plan we've discussed with the independent monitoring team for the federal consent decree and the Office of Attorney General. It's a plan that we've discussed, as I said, with many stakeholders along the way. But we are responsible for this choice, and I want to be very clear about my intention to make this project successful and to do it in a way that continues the trust and the hard-earned reputation that I know has been improving for our agency over time. Lastly, I'll just say that the work of reform takes reevaluation. Reform isn't just doing the same thing over and over again, but actually evaluating what is and what isn't working. This process, this program, and what I see as the end result for us as an agency, that's what reform looks like to me. That's about how I deliver what I think is the actual product in an investigation that our officers, that our community members, that all of our stakeholders deserve and expect of us as an agency. So I appreciate the opportunity to come tonight to talk to you about it, and I anticipate there will be questions.
Yes, before we begin with the questions, Commissioner Brown and Commissioner Loisen, I know Yale has a point of privilege had some more context to give, so you can go ahead and provide that context and we'll come into your time.
Thank you. Thank you, Chief Person. Commissioner Loisen and I want to speak in favor of COPA's plan to close certain kinds of older cases. We've worked very closely with Chief Person and her staff over the past 9 months and continue to be impressed with their diligence and commitment to improving COPA at every turn. Part of that improvement must include the ability to focus on new and current investigations that have been appropriately screened and undertaken with an eye toward timely and efficient review, investigation, and assessments for appropriate resolution. Due to a past inherited backlog, staffing challenges, increased jurisdictional obligations, and frequent administrative change, COPA has struggled with completing investigations in a timely fashion.
to be clear that we are confident that a lot of these issues are being addressed. And COPA has a very robust and effective plan to maintain efficiency into the future. But in order to do that, they need to be able to administratively close older cases that have no chance of resulting in any outcome other than dismissal after arbitration. While we know that this decision might cause some family and community members pain, and I just want to say that we are very aware of that, and that has been something that we have most thoroughly considered. We never want to do that, but we also believe this to be a more compassionate step in the long term. We support this decision wholeheartedly and believe it is a reasonable and practical next step. Commissioner Brown and I recognize that this is not a perfect solution. And its decision, again, was not made lightly or without consideration for its impact on all stakeholders. But ultimately, we believe that it is the best solution at this time, and one that will ultimately benefit community members, police officers, and COPA in the future. In addition, I was not aware that the senior staff of COPA would all be present this evening, but I do want to thank you and commend you all for being here tonight. I know that this was a difficult decision for your entire team, and I think that your presence here tonight, along with Chief Kirsten, demonstrates your commitment to making this work and ensuring that COPA is not in this position again in the future.
Thank you, Commissioners. And I want to add a little bit more context as a point of information for the community members that are present here and seeing this through Zoom or through a recorded meeting. The point of this presentation is not for this commission to be taking a vote. And Adam, correct me if I'm wrong, but our power over the Civilian Office of Police Accountability is not one where we micromanage every decision that they make. It's been our process to ensure that Commissioner Brown and Commissioner Moizan have a direct line of communication and collaboration with the chief here present, and she has that collaboration with her staff as she sees fit. We will not be taking a vote on this issue because this is an issue that is within the jurisdiction of COPA. But I do want to point to all the community members that might be observing us that we are definitely integral in making sure that this decision is carried out thoughtfully. That's accountability for everyone here on behalf of COPA, but also on behalf of this commission, because we have been aware of this. We've had a lot of long conversations about this, and I'm making us responsible for this as well, because it's everyone's business. So just a point of information and a point on how this process will work out. Now to the fun part. I will open up the floor for commissioners who might have questions. I see Commissioner Troncoso, and then Commissioner Terry, and then Commissioner Clifton.
Thank you for that presentation. I definitely can appreciate the transparency of a head of the government department coming out here and telling us what's going on in their department directly to the community. So the whole idea of this move being the reallocation of resources towards fresher cases, can you give some sense of the scale of value that might come from this to cases that are, say, filed tomorrow, whether it's a number of staff members that might be shifted away from those old cases to newer cases, or any kind of projections you might have as to a reduction in the average time of a case filed tomorrow, for example?
So I can say thank you for the question. I can tell you right now our average case duration is just under 2 years on average. But that's because we have outliers that are the 3 and 4-year-old cases, and then we have outliers that are complaints come in and there isn't actionable misconduct and it concludes relatively quickly after a preliminary investigation. All those numbers are in one pool. So the goal is to make it not the average, but the ceiling for cases being no longer than 2 years, really closer to 18 months, quite frankly. So the way that we're structuring the program is not going to divert any resources from currently assigned cases. We have spent time creating this operational unit within investigations, having 2 supervisors that are going to be solely devoted to this work, not carrying other caseloads, as well as a director of investigations, and led, of course, by the deputy chief of investigations that's here tonight as well. So there's a specific unit that is not coming to this with a whole bunch of their own existing cases. I also think that's important for two reasons. Consistency, having a small group of people applying this methodology and criteria will help for greater consistency. And then it doesn't create any sort of incentive. These aren't their personal caseloads. So it doesn't create any sort of personal incentive for an individual investigator to be more inclined to try to close something this way just to reduce their caseload. So I'm hoping that objectivity also helps make sure that we identify the right cases for this closure. Having said that, there will be cases that, these are going to be judgment calls that ultimately get made. But the thing that I think community members, this commission, and other stakeholders should take heart in is that we have the ability to reopen cases as well. And so, and our closed cases are always reviewed by the Public Safety Inspector General and her team. And this is something that I've communicated what's happening with this plan to their office and anticipate having a full briefing so that once it's up and running, they'll know where to look and what to try to identify. But I certainly think there will be some short-term gains, and then I'm confident by the end of this program, we will see a significant decrease in our caseload.
Thank you.
Thank you so much, Chief Kirsten. So, two quick questions. The first, as you mentioned, the lack of timeliness in these cases end up failing in arbitration. Can you just share it with the community so that they understand how cases end up in arbitration, like what that actually means?
Sure, and I'm gonna, if anyone in the audience, if I misstate any of the rules specifically, but basically, of course, officers that are in the two unions that you guys mentioned earlier have the right when they are there's discipline charges being sought against them, suspensions or more serious discipline such as separation from the police department, they have the ability to contest those disciplinary recommendations. And for the most serious disciplinary recommendations, which is typically anything for police officers, anything 1 year or up to and including separation, 1 year suspension up to and including separation, those most serious cases go to the Chicago Police Board. Lower level amounts of suspension, anything under a year, typically goes, if they're fighting the discipline, goes through an arbitration process. Really important distinctions between arbitration and the police board. You heard Vice President Wolf and Director Caponis up here tonight talking about transparency around the police board, talking about all the information they put on their website after their meetings, their public meetings that anyone can attend. Arbitration is a closed-door process. It's one arbitrator that makes these decisions. It's not a process unique to policing at all. It's a process that you see in labor law across the spectrum. But it's one person making a decision kind of up or down as to whether discipline should be imparted in a particular case. And what we have found by talking extensively with the Department of Law, with some of the CPD folks who also are fighting to be successful in arbitrations themselves, as well as our own internal legal department, is that we are often very hamstrung by investigations that just took too long to conclude. There's an actual time limit in the supervisor's contract for sergeants and lieutenants of 18 months or greater, and in the officer's contract, even though that provision does not yet exist in their contract, arbitrators have uniformly been applying the same timeline to FOP or regular officer cases. So that's what we are up against. And in addition to timeliness being a factor, if arbitrators find the discipline recommendations are too high, they can reduce them. So we want to be able to put the strongest case forward to be successful. And in addition to reevaluating our caseload and making some of these hard choices, our legal staff is also already engaged in an office-wide training on how to better testify, how to better position our cases to be successful in arbitration based on everything they've learned over the last 6 months. And the reality is, you actually start testifying in an arbitration the first time you ever, as an investigator, make an entry in your case file, because your case file is your evidence. Your evidence is what comes in arbitration. So getting those good documentation practices and those careful appreciation of timelines and benchmarks ingrained in our culture, that's what's going to ensure success beyond this project and sustainability for us in the future.
Thank you so much. And my other question, I think you sort of alluded to this. These particular cases still will be made public with the decision of the type of closure that you're proposing, correct? So this information will still be readily available.
In fact, even more so. So we have a very robust public dashboard, a data dashboard that has a lot of different unique customization and filters that a general user of the public can avail themselves of. We are going to be creating, when the program launches, and I kind of glossed over this, sorry, it's up on the screen, creating sort of a special portion on our website dedicated to displaying the data specific to this project. So understanding the number and kinds of cases and number of training recommendations that are being made, et cetera. We want to be honest about this. This isn't something that we are hiding from. We understand it's our responsibility to explain this as we seek solutions to fixing it. So making that transparent on our website is important. We're also going to be issuing, this was a recommendation from the federal monitoring team, for the consent decree, we will be issuing a written special report that just goes into more detail, kind of what I was talking about tonight. So for folks that don't tune into this or want to see a little bit more of the data behind what I'm trying to explain here tonight, there will also be a longer written document that will be publicly available when the program launches also.
Thank you, Chief Pearson. First, I want to affirm your leadership. I really do appreciate you kind of wearing a coat and coming here and transparently sharing something that would obviously be perceived as negative. So I think that's a huge affirmation of your leadership and what you're trying to do with the department. I appreciate it. And said that, I would also say that this is kind of sad. I'm sure you do too. I'm curious to know if you have a sense, and I apologize if this was in the report or in your comments. Do you know what the total number of complaints that will not be investigated? What is that number?
I don't know of any total number of complaints that will not be investigated. There are about 850 cases or complaints that will be evaluated as to whether they meet this criteria. But as we laid out, there are a whole host of reasons why we would not consider closing a case in this criteria. And please also understand, a number of these cases, the original complaint may come in as a Fourth Amendment case or something of that nature, but a lot of times those original citizen complaints are not sustained. We don't have substantial evidence in order to sustain those cases. But in the review of the body-worn camera or other evidence, as we are obligated to do under the consent decree, we end up bringing other ancillary operational violations for failure to accurately report something or fill out an ISR, whatever the issue may be. And it's often in many of those cases, if not the majority of the ones that they have started to look at, that those are the kinds of things that would have a sustained finding, not the original citizens' complaints, if that makes sense. So it'll be some of those operational violations and things of that nature. That will be the majority of the training recommendations that come out of this.
So then I think I sort of understood that already. You basically outlined the metrics for which you're going to evaluate, I think it was 2019, 2020, majority 21, for dismissal, I'm not sure what the language is, but not actually completing the investigation in the case. So we don't know yet tonight what the number will be.
Correct.
To complete that evaluation.
Correct.
That's just one thing I want to know. I would be, for Commissioner Wisen and Brown, I would be interested in knowing what that number ends up being. And then, could you just help me understand a little bit better, like, why do we know it's guaranteed that if it goes to arbitration, it could not result in any sort of remedy?
Well, we know for anyone that's covered under the Sergeant and Lieutenant's union that contract, that control. So anything over 18 months for sure, that's a hard and fast rule. And then we can just look at past practice over the last several years of what's coming out of all of our arbitration awards. And, my deputy chief administrator spends an inordinate amount of time testifying in these arbitration hearings. I myself have to testify in these arbitration hearings. CPD's leadership has to often testify in these arbitration hearings. And you see award after award where timeliness is, if not the biggest controlling factor, a very significant controlling factor. It's typically not the integrity of the investigation, the independence of the investigation, even the reasoning that we've applied to many of our findings. It's about the timeliness and or the past practice of prior disciplinary recommendations. That is a different issue that I'd be happy to spend another 20 minutes talking to you about, but that's not something that will be solved for in the scope of this project. But what this project does is it positions us to put forward the strongest cases prospectively.
So just so I make sure I understood you correctly, the reason for believing or stating that things don't and some sort of remedy available cases of a certain duration are literally just dismissed simply because of the duration, and that's a pretty standard practice. It's not a requirement, but that is a practice that you noted.
Yes.
Is that okay?
Yes.
Thank you. To me, I just have two things to comment on. One, I think, really important thing, which is I understand leadership role when you have certain constraints and have to make tough decisions. And I've already commended you for being transparent about that. It does seem like there's wisdom in your decision. What is the plan to make sure we're here again? That's what I really want to make sure we hear is that 4 years from now we're not dismissing 2023, 2024, and half 2025. And that's not a number. I'm not saying that's what you said.
I know, I understand.
So.
No, I understand. That's actually a question. I appreciate the question, and I certainly had it posed to us in other venues and posed to us by your fellow commissioners. A couple of things I want to highlight. I mentioned in my mad dash through our data earlier that we've had other attempts and iterations at reducing this caseload, and the focus on our intake unit in particular back in 2019, and then again really sustained throughout that time, has been really key in what's going to lead largely to the success of sustaining this progress going forward. Several years ago, going on 3 years ago, I think this summer, our intake unit, that's the preliminary investigative unit, when our caseload was peaking to its highest, their numbers ballooned to nearly 800 cases in that preliminary intake posture. And some of them stayed there for far longer than they should have. We were in the process of making gains in that area just when the civil unrest happened from George Floyd. I can report here today that all the cases in intake are no more than, I think, 34 days old is the oldest one, as opposed to some that were there lingering for over a year. And there's anywhere from 40 to 60 total cases in our intake unit. Why this matters is because being able to identify what is coming in the door is incredibly important when trying to maintain a right-sized caseload in the general investigations unit. And when you look at our data a little bit closer, the ratio of cases that are coming in and getting assigned to general investigations after a preliminary investigation, not getting closed after a preliminary investigation, but cases that need further misconduct investigation, that number is significantly smaller month over month than the number of cases we're closing in general investigations. That was never the case before. We were bringing everything in, sending everything to general, and there was no calibration at all. So the way in which we've done that is, number one, the ability to screen our cases is better and different, like I said before, not knowing what we know now about how Fourth Amendment complaints do and don't translate to allegations of misconduct. 4 or 5 years ago, we took a lot more of those on than we take on now, for good reason. Also, with the proliferation of body-worn camera, obviously we have a lot more concrete evidence than we ever had before in these investigations, and we know better how to use that decisively earlier on in the stage. And just basically using our discretion as to what requires misconduct investigation that leads to disciplinary recommendations versus some of the other off-ramps that never existed before. We have now a pilot program for complainant-centered mediation for lower-level cases, the exact kinds of things I'm talking about closing from 3-4 years ago. We have a different path for those cases now. We didn't have that path before. There was something called mediation before that is still an effective tool where an officer can agree to a certain amount of discipline and we don't have to go through a full investigation and they waive their right to grieve or arbitrate it. That process has not been happening between COPA and the unions since COPA became an agency. We have to go back to the table with the unions about how to find agreement where we can on certain kinds of things like being able to turn on your body on camera. So there are other mechanisms in place to make sure that that doesn't happen. And then lastly, this unit that we're using for this special project, that's not a temporary unit. They are my investigative operations unit, and their job is to leverage our quality management division, their leadership within investigations to continue to maintain efficiency and effective resolution of these cases. We have now, because of the goal-setting process of CCPSA, started using our data as a management tool internally, not just a transparency tool for the public. So we know more now about individual investigators' caseloads, productivity, and where we need to support staff differently in order to maintain these levels and sustain them going forward. forward. So I know that's a long-winded answer, but I can just tell you that I'm excited about sort of the next phase for COPA because I really believe that we can achieve the progress that we're going to make here, we can sustain it.
So, and you have another question after me? Okay, that's okay. Just because I told you we only have 20 more minutes, I want to let you know that we're going to stay on this a little bit longer. And for the public that is here, I know that this has been a long meeting, we've given you a lot of things. This is a big issue. And I know that, being in your hour plus of being here means it's hard. We appreciate it. You have to go place, there's other ways that you can stay engaged. There will be other ways that you can learn about it. But we do want you to stay. And we do want you to get the questions that we as commissioners want to ask because it's important that we do it on behalf of you, the community. So just want to point that out to people because we are over the 8 p.m. mark. So go ahead, Commissioner Ellis, and then we'll open up for a few more questions if folks have some.
Okay, thank you, Mr. President. Well, first of all, thank you for that thorough explanation. I think I got a good 85% of it. It did make sense. A number of things you said made sense, and it does give me some comfort in believing that we won't be in this position. I also trust Commissioner Brown and wise enough to I trust your leadership, honestly. I think the leadership has been exemplary. So I appreciate you answering the question. For those after the measure who decide which cases will not be investigated, take this with a grain of salt. Maybe it's a good idea, maybe it's not. I've been trying to put myself in the position of the person who's filed a complaint and who's received news that it's not going to be investigated. And I don't know, I'm not a PR person, but I feel like a heartfelt apology and just recognizing that is a hardship that they're experiencing as a failure of the office. I know that you weren't there, but it is you are representing the office. So some sort of, I'll just leave it at that, I don't know, but some sort of apology, just recognizing that this is not anybody we want. And then second thing is, I think you actually already commented it, so maybe is less of a question and more of a confirmation of something I heard. But have you considered any process for people who learn that their complaint has been not investigated, and then allowing them an opportunity to refile or show some special grievances as to why, don't drop this one?
Well, so we're a couple of things. First of all of these cases are being and have been investigated. So it's not as if this complaint never got investigated. This is saying that we can't move this investigation forward with a disciplinary recommendation based on the point in time that we are now at. So it's not to say often interviews were conducted, certainly review of all relevant body-worn camera or any other evidence, review of departmental documents and reports. The cases have been investigated, otherwise we wouldn't be able to determine whether it would be even appropriate to move forward in this posture. So I just want to be clear on that. Second of all, I wholeheartedly have no issue with, taking responsibility for extending apology for what I'm sure will be difficult for some people. But I also want to add context that this difficulty can come in the form of this program, or it can come in the form of an arbitrator's decision 2 more years from now. So there's also that component that where these cases are at and what we know about the system, this is about trying to take what I can and try to create whatever path forward for an officer's potential rehabilitation, if that's appropriate through training, we can possibly avail ourselves of. But certainly, and I touched on this, our case liaisons, their whole job is to talk to our complainants and officers when they have questions about the status of our cases, our process, our procedure. They are getting special training on how to have these conversations. And I will continue to make myself available. You gave me a little bone and said that you weren't there when this happened, but I was. I've been at the agency the whole time. I haven't always been in this role, and most of the senior team that's been here with me, they haven't been in the roles that they're in now largely either, but we've all been a part of this. And so whether I was chief or not, I'm chief now, and this is our situation now, and I have no problem taking responsibility for that and extending my heartfelt apologies and feelings of empathy for anyone who feels as if their case wasn't heard. That's not what we want out of this. We heard these complaints. We simply didn't have a path to resolve them in a time that was going to be successful, and now we have to do something about that.
Well, again, I just want to thank you and commend you for your leadership, and to the Vice President. While Wolf is still here, maybe a lot of those interviews and things that they conducted, although we're not able to yield an outcome, could be part of what you received in complaint histories to give you the fuller picture of this officer's background. Just an idea.
All right, Commissioner Brown, Commissioner Lorenzo, do y'all have comments or questions before we kind of come to the end? It's okay if you don't. So I promised the commissioners that I wouldn't ask any questions, but I'm going to ask a few rapid fire questions, and it's not to be catch questions, but I think there's a couple pieces that I've heard that I still haven't heard, and they're meant to be sort of reflecting some of the questions that community members might come up with. So when do you think this is going to happen? When do you think people will be notified? I understand that you still have to do the evaluation of what cases will and will not be administratively closed. That's right. When do you expect, and just a prediction, I won't hold you to it, that this will be something that people will be notified of?
Probably not any sooner than early August. The program is going to actually launch in July on the 17th, and we want to be proactively calling people whose cases might find themselves in this posture prior to them receiving an automated email notice or a letter in the mail. So I believe as soon as August, we would start making some of those phone calls.
So noticing the trend, and Charlie, if you could put the trend from the 2017 to 2023 slide. This is, I think, during during May of 2020 to now, that's been during the peak until now, that's been the longest sustained decrease in cases since the organization's inception.
Correct.
So why do it now if this is the only time when we're trending now?
As I tried to explain before, we're already heading in the right direction. This actually pairs with Commissioner Nellis's question about sustainability and how do we not get here again. If you look at our data, we're already on a different path, and that's because of some of the controls we put in, particularly around our intake unit, as well as other efficiencies that we've identified in general operations, general investigations. But the reason is one of time. So every month that goes by, a case that was 18 months old yesterday is going to be eclipsing 19 months old by the end of the month. So at the rate that we're achieving this progress at, it would still take several years to get to a point where we have significantly reduced our caseload. And so this is an accelerant that I think is absolutely necessary.
Thank you. I think I know the answer to this question, but again, for the public to know, why not just hire more investigators?
That would certainly be an option available, but I would have to note, and this didn't make it onto the data, we have run vacancies due to staff departures throughout every single year of our existence. I know your commission can attest now to dabble in city hiring, the challenges to adequately staffing and maintaining talented staff. We're super fortunate at COPA. We have a lot of folks that come here, learn a lot, enjoy our great academy, and then go off and do civilian oversight for other cities. That's wonderful. So there's just an honest thing about being a good steward of the resources we have. And until I have the caseload right sized in the way that we need it to, I can't meaningfully evaluate how many additional investigators we actually need. Perhaps when we conclude this project, we have what we need. But until that time, it's hard to make that calculation and make it in good faith.
So again, in the hope of fairness, I'll have you know, and I think the public knows that we've grilled, for example, the police department on the process for challenging being on the CIS, right? And that's one of the reasons why we still have this ongoing communication. You mentioned that this is not like a delete button that will get rid of all the investigation or the case's history, but more like putting it in bin and making sure that it's legally closed. If I'm a person that has found something new, some new information about my case that could potentially reopen that investigation, tell me about the process after I've been notified, hey, it's late December of this year, I believe that there's new information that will reopen your case. What does the process look like?
Irrespective of this program, it's always been part of COPA's policy and practice that if anyone asks to reopen a case, a complainant, the Office of Inspector General, that's a request that we can review. In fact, sometimes in our recommendations, the department itself, CPD, asks us to reopen investigations to conduct additional investigatory steps, etc. So this is laid out in the COPA policy. It's typically, if it's an outside request from a complainant coming to ask to have a case reopened, then our legal department does a screening of it to see whether there is a basis to reopen it. It's laid out in our ordinance sort of what those standards need to rise to. But there would be a calculation as to whether there would be a likelihood of success for reopening this case too. So the introduction of new material evidence, while important, if it still is a case that is well beyond an arbitration timeline of likelihood of success, that will continue to be a factor. So, but those are specific things that we will be talking to these complainants about in this program, but always with all complainants, that is an option available to them.
Thank you for answering those. We can add one more thing, yes.
So I just want to add to prove to all of you that Beth and I pay attention. The chief did touch on this. I do want to emphasize that over the course of the 9 months that we've worked with COPA, and even in our goal setting process, our most recent update on goal setting, one of the topics of discussion that we frequently have is retention of employees and the processes which the chief's administration has utilized to ensure that employees are properly trained, properly supervised, getting regular performance evaluations, and having opportunities to progress within COPA. I will say that COPA has been extremely successful at doing that since we have been working collaboratively with them. Actually, to the point where in few meetings I had to say, like, stop telling me the good stuff, we gotta talk about some of the bad stuff, because there has been so much progress in that area and such a strident effort to make sure that they're keeping personnel in place and motivating personnel in a way to ensure that the numbers that we're seeing here are going to be numbers that we see in the future. And so I do think it's very important to emphasize that, and as a person who has spent a lot of time in government hiring and understanding how difficult that is, I think that COPA, over the past 9 months again, routinely comes into our monthly meetings with new ideas on how to better advertise positions, better recruit, and better retain the people who are currently working there. So I do feel very strongly that that component of the process is something that the chief has done a very good job of getting a handle on.
Thank you, Commissioner Louise, and thank you, Chief Person. I think that will conclude this section of this agenda, given that we've greatly hurried on. We appreciate your leadership. We appreciate this tough decision. We know that this is a decision that no one would like to make. But we're here to continue to be supportive and continue to figure out ways of improving everyone's involvement with public safety and making sure that we continue to get that public trust. So thank you for your time. Thank you all. So we will now move forward with some housekeeping matters, and then we will finally come to the end of the meeting. If anyone needs to get up and stretch, that's totally okay. So we're opening the miscellaneous business part of the agenda now. Is there any miscellaneous business that anyone would like to point out? Okay. Seeing none. I just want to let you all know that we are on social media, and we have awesome social media. I know that everyone here probably already follows us. For the people on the stream, follow us on Instagram, Twitter, and YouTube at CCPSA_Chicago or at Chicago CCPSA if you're on YouTube. Okay. Is there any other business that the Commission would like to bring on? Commissioner Brown, you have the floor.
Just quickly, we're coming to the close of Pride Month here in Chicago, so want to acknowledge that, and also want to give a shout out to CPD, who helped make the parade a safe and enjoyable event for all who were in it. So just wanted to say that. Thanks.
Yes, one other thing, just in the spirit of one group of community members trying to support another group of community members. COPA has an application due tomorrow for their Community Advisory Council. And I believe it's 7 to 15 people that they'll meet with on a quarterly basis to get the perspective of the community. So, you know, if you want to be doing their equivalent of sitting up here, I highly recommend that you apply to that. And, you know, this has been an amazing experience to be on this side of the table for this, so I'm sure that will be too.
Perfect. Commissioner Trunco. Somebody else has Commissioner Nelson, thank you very much.
I just have one thing I want to make sure the public's aware of, because we just happened yesterday or today, which is the ACLU did file a lawsuit against the Chicago Police Department for discriminatory practices in traffic stops. So you can Google it and look it up online. The complaint, 144 pages is there if you want to read it. But I do think it's just a good thing for the community to know and be informed about.
So, seeing no further miscellaneous business, I will announce now the next meeting. The Commission's next regular meeting will be held on Thursday, July 27th of 2023 at 6:30 p.m. We will announce the location of the next meeting when we post the announcement on our website. And yes, it's going to be already my notes are updated. And yes, you can follow us on social media. Okay, great. Now, seeing no further business, I would like to thank you all for joining us tonight. We hope to see you at the next special meeting to vote on the nominees to serve on to vote on the nominees who will serve as police superintendent. The date, time, location of that meeting will be determined soon and made public. And we hope to see you at the Commission's next regular meeting, again, July 27th, you see the information above. And we hope that everyone here will continue to stay engaged and encouraged by the work that is being done. There being no further business before the Commission, this meeting is now adjourned. Thank you all for